Hello everyone, my name is Keerti Koli and today I'm going to discuss about the dissolution of partnership by court order under Indian Partnership Act 1932. So let us have a brief introduction about dissolution of partnership, the meaning of dissolution of partnership firm, the modes of dissolution of firm and in what ways it takes place and steps in dissolving the partners. So let us know the meaning of the dissolution of partnership firm. Under Section 39 of Indian Partnership Act provides that the dissolution of partnership between all the partners of a firm is called the dissolution of a firm. It implies that the complete breakdown of a relation of partnership between all the partners. If a relationship between all the partners of firm is dissolved, then it is known as dissolution of firm. In case of dissolution of partnership of firm, the firm ceases to the exist. This process includes the discarding and disposing of all the assets of firm or settlements of accounts, assets and liabilities. And the next slide we can discuss about the modes of dissolution of firm. The first one is the dissolution by agreement. It is under section 40 1932 of Indian Partnership Act. A firm may be dissolved if all the partners agree to the dissolution. Also, if there exists a contract between the partners regarding the dissolution may take place in accordance with it. And the second one is the compulsory dissolution. It is under section 41 of 1932 of Indian Partnership Act. It tells that it takes place under following cases: insolvency of all the partners or all but one partner, has this makes them incompetent to enter into a contract. When the business of firm becomes illegal due to some reason. When due to some event it becomes unlawful for the partnership firm to carry its business. We can know this by giving an example. Here I have given a brief example to understand more about this. A partnership firm has a partner who is of another country and India declares war against that country. Then he becomes an enemy. Thus the business becomes unlawful. And the third one, which is when certain contingencies happen, that is under section 42 1932 under Indian Partnership Act. So this tells that the dissolution of firm takes place subject to a contract among the partners. The firm is formed for a fixed term on the expiry of that term. The firm is formed to carry out specific venture. On the completion of that venture, a partner dies, a partner becomes insolvent. And the next is the resolution by notice under section 42, under section 43, 1932 of Indian Partnership Act. It tells that when the partnership is at will, the dissolution of a firm may take place. If any one of the partners gives a notice in writing to the other partners stating his intention to dissolve the firm by dissolution of notice. And the last one is the dissolution by court. It is under section 44 1932 of Indian Partnership Act. It tells that when a partner files a suit in the court may order the dissolution of firm on the basis of following, that is insanity, permanent incapacity, misconduct, transfer of interest and perpetual loss. Let us have a brief meaning about these five resolution by court. First one is insanity, in case where a partner becomes insane. And the second one is permanent incapacity, in case where a partner becomes permanently incapable of performing his duties. Third one is misconduct, when a partner becomes guilty of misconduct and it affects the firm's business adversely. And the fourth one is the transfer of interest. In case where a partner transfers the whole of his interest in the partnership firm to the third party. Perpetual loss in case where the business cannot be carried on except at a loss. And the next slide, we are going to discuss about the dissolution of partnership in which takes place in any of the following. The first one is the admission of a new partner. Second one is the retirement of an existing partner. Third one is the death of an existing partner. Fourth one is insolvency of a partner as he becomes incompetent to contract. Thus, he can no longer be a partner in the firm. Fifth one, on completion of a specific venture, in case the partnership was formed specifically for that particular venture, on expiry of the period for which the partnership was formed. The next slide is the 5 steps in dissolving the partnership. The first one is review your partnership agreement. While some partnerships don't require a formal or written agreement, most partners choose to have one anyway for protection. If your partnership has no partnership agreement, then all you need to do is give notice to your partner. And the second one is discuss with other partners. This includes discussing particular obligations such as debts and future liabilities. You may want to outline your plan for dissolution in a meeting to ensure that a satisfactory resolution is reached. Third one, file dissolution papers. While it may not be required, it's a good idea to file a dissolution of partnership form with the state to formally announce and give notice of your partnership ending. Doing so can help you resolve any issues involving further obligations or debts with the partnership. And the fourth one is notify others. Make sure you also notify other parties of the dissolution. This includes your landlord, your employees, your customers, and any other government entities that have registered your business or issued your license. Settle and close out all accounts. Make sure that all your creditors are notified and that your debts are all paid off or settled. Lastly, you will want to distribute all your assets accordingly. That is usually in accordance with the partnership agreement or whatever you and your partners have otherwise agreed upon. And make sure that all relevant bank accounts are closed. So here I end my video. Thank you.